If you bring a medical malpractice case against your careless doctor or hospital staff, and it turns out that you had a prior lawsuit from a car accident case in the past, does the defense need to know about it? And importantly, when they learn about it, can they ask you questions about the injuries that you suffered in that car accident case? Would you like to know the answers to those questions? Come join me for a walk through the neighborhood as I share with you the answers to those questions. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. The answers are yes and yes. The defense will know and will learn by having done a background search on you that you have brought a lawsuit in the past. They will ask you during your pretrial deposition, your pretrial question and answer session, whether you have ever sued anyone in the past. They will know that you have, and you are required to answer honestly and truthfully. And you may turn around and say, what does a car accident case have to do with a medical malpractice case? The answer is nothing, except the injuries that you suffered in the car accident case. The defense will be entitled to probe and to ask many questions about the injuries that you suffered in that prior lawsuit. Likewise, they will be able to request and obtain copies of the documents in that car accident lawsuit to see for themselves what injuries you claimed you suffered as a result of that car accident. And again, you might be saying, what does that have to do with the injuries you suffered in the malpractice case? For the most part, the answer is it has nothing to do with it, unless the injuries you are now claiming in your malpractice case exacerbated and made worse the injuries that you had from this prior car accident. In that instance, not only will the defense be able to ask you questions, but they will be allowed to probe to determine what injuries you had prior to your car accident case, what injuries you suffered as a result of the car accident case, and what injuries you now have as a result of the improper medical care in the case you are currently bringing. So the defense is entitled to learn this information. They're entitled to find out and distinguish the injuries that you have in the malpractice case and compare and contrast it to the injuries that you suffered in the car accident case. So let's say, for example, in the car accident case, you suffered a fractured femur and you needed surgery to correct that fracture. And now in the malpractice case, you suffered injuries having nothing whatsoever to do with your fractured femur and the treatment you received to fix that. Okay, they're still entitled to learn about it. And they're still entitled to understand the differences between the injuries you had in the car accident matter and the ones that you are now claiming in the malpractice case. But let's say that in the malpractice case, you are now claiming that your injuries were made much worse. The injuries that you had from the car accident are now made much worse, and you need additional care and treatment to fix the problems as a result of improper medical care. The defense will spend a great deal of time and effort and energy learning about all the treatment you received in the past, as well as all the current treatment you are receiving now. And they will also want to know whether any doctor has indicated what exact limitations and injuries you have now because of the malpractice, separate and distinct and apart from the injuries and limitations and restrictions that you had following the car accident case. So, why do I share this quick information with you? I share it with you to open your eyes and help you understand how these types of cases work in the state of New York. You know, I realize you're watching this because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.